be back with you, back in the studios of Good News Community Radio with attorney Megan Gedye and Lizanne Hattingh. Megan is also the founding member of S.T.E.P, Taking Safe Steps Beyond Abuse with Victims of Abuse and their support system. So Megan, before we continue with Lizanne, if you can just maybe differentiate between an attorney and an advocate.
So an attorney is someone who, in practice, there's not that much difference between an attorney and an advocate. And the new Legal Practice Act has actually sought to close the gap between advocates and attorneys. But advocates essentially are trained to argue in court. They write a further exam, whereas attorneys kind of do more of the paper pushing. It depends which area of law you're looking in, but you normally brief an advocate as an attorney to argue your matter in court.
Is there a cost to a family advocate?
The family advocate's office is free. There may be costs involved based on what the children might need. For example, other experts like psychologists or psychiatrists. Yeah. So those are additional costs that might be incurred. But the office is through the department, and it is a free service.
We'll cross over to Lizanne for more of those questions that need to be answered.
Thank you, Venora. Megan, coming back specifically to domestic violence, what is domestic violence in legal terms? What does our law say it is?
So domestic violence has quite an extensive definition, and it's defined in the Domestic Violence Act. And it really is very all-encompassing. So the obvious one is physical violence, controlling behavior, economic abuse, exposing a child to domestic violence, elder abuse, related person abuse, sexual harassment, and even spiritual abuse.
Megan, within a marriage, when is sex legally defined as rape?
That is a good question. The definition of rape doesn't change in a marriage. If you haven't consented to sexual intercourse, then it is rape. So the fact that your husband has forced himself, it's still, and you've said no, that's rape within a marriage.
It's just much harder to prove?
Sure.
Thank you, Megan. With regards to protection orders and interdicts, is a protection order the same as an interdict? When do I know I need to get one? How do I get one? How long does it take? Help!
Okay, so protection order is a domestic violence interdict, and you can obtain one at the magistrate's court. So the process roughly, and I mean obviously you can read up online for more details, or the listeners can. But roughly what you would do is you would approach the police and you would report the abuse, and then you would obtain a domestic violence interim interdict, which is then served on the abuser. And the terms of the domestic violence interdict will stipulate what the prohibited behavior is. So, for example, cannot come onto the property, cannot abuse you, cannot phone you, speak to you, whatever the case may be. The obvious ones would be cannot hurt you. Once an interim interdict is obtained and it is served on the abuser, then the police are mandated to act on that. So if one of those terms are breached, then the police are required to arrest. What I'm circling there is that an interim interdict is as enforceable as a final interdict. It's just you have to go through the process of having the interdict finalized. And the reason for that is because your abuser has a right to be heard. Everybody has a right to be heard in this country, in most countries. So they have a right to respond to the allegations against them.
Thank you, Megan. I've just seen something in my book which I'd just like to read. It's a very short answer to the question. What support services will be offered to a child who applies for a protection order? And I'm reading as follows. the clerk of the court must explain the rights and remedies that are available to a child in terms of the Act in the language of preference and in a manner understood by the child. The child may testify in a private room. In other words, without the physical contact with the abuser and with the assistance of an intermediary. The role of an intermediary is, among other things, to sit with a child in a private testifying room wearing earphones to convey to a child witness questions from court. I'm going to read that again. The role of an intermediary is, among other things, to sit with a child in a private testifying room wearing earphones to convey to a child witness questions from court in a language and manner that a child may understand. I've even spoken to a child psychologist, and today you get, I don't know what they're called, you get counseling dogs that are allowed in courtrooms with children who understand the courtroom process and offer assistance to the child just by their mere presence. And I think that is absolutely amazing.
Yeah, good comfort. That's wonderful.
Megan, I'd like to just chat a little bit about how we as, in essence, single parents after our divorce can protect the future of our children. Broadly, what would you say, how do we ensure that our minor children are kept safe if something were to happen to us and we are no longer there?
So I'm going to start with explaining what will happen when you are there, and then we can move on to that if that suits you. So once the parties are divorced and an agreement has been reached between the parents on how you will parent those children, the obvious first prize is to follow that plan. The concern, I would imagine, in abusive relationships is that's probably not going to happen. There's not going to be any type of meaningful agreement between the parties, certainly nothing that can be enforced. And so you might need to take more stringent measures to protect your children. So our Children's Act is really a very impressive piece of legislation. It's very forward-thinking. It's very first world. And it allows you to protect your children. The only difficulty is that you have to apply to court. So, for example, if you would like sole care of your child and it cannot be agreed, it can be applied for through the court. So if we work on the starting point that it won't be agreed because you're not dealing with an agreeable person, then your next step is to apply to court for sole care. Just to briefly explain the difference between care and contact, they are kind of mirror images of one another. So whichever parent has care of the children, the other parent will have contact during that time, and vice versa. If you are going to apply for sole care, that may be with or without contact, depending on the relationship between the child and the parent. And your overriding requirement in all things relating to children is what is in their best interests. And so if you can prove to the court that it is in the child's best interest not to have any contact with that parent, then that is what the court will consider.
How does one prove that?
Well, abusive parents would be, to make an allegation that there is an abusive parent would certainly result in the court ordering, or not certainly, but it would certainly convince the court that it's not in the child's best interest to be anywhere near that parent.
And would that entail necessarily making a criminal charge against the abuser or not?
So I obviously don't recommend that you play the two systems up against one another. If there is real abuse, and it must be reported through the criminal justice system as real abuse, and then obviously that is going to lend credence to any application you may bring to court to have sole care of the child and guardianship.
Thank you. And if something were to happen to me, and I'm no longer there, and the children have another parent who is not an agreeable person, how do I protect my children now for that eventuality?
Okay, so you can appoint a legal guardian in your will. A natural guardian, as I explained earlier, of the children is their parents. So when you appoint another guardian in the will, it doesn't guarantee that that parent would be excluded, but it would show that your intention was for somebody else to be the guardian. And then, yeah, but like I said, it wouldn't automatically exclude, for example, your ex-husband